Welcome to Immigration Practice, where we study immigration law to practice it better. My name is Joseph, and today we're going to be exploring some of the nuggets regarding non-immigrant visas. The first one is the separation between the desire to immigrate and the intent to immigrate. We've always counseled our clients to distinguish that and help them argue it, but I never knew there was actually support for this. So I'm going to read this to you. A non-immigrant applicant's desire to remain in the U.S. must be distinguished from his or her intent to remain. And what that is that was a case law that reversed an E-2 denial where the applicant expressed the desire to immigrate, but did not intend to, if not permitted. And this makes perfect sense, right? You invested in the US, you want to go to the US. Maybe you're an F1 international student. You've been here for 4 years, 8 years, 12 years. Of course, you have the desire to. And just because you accidentally said you like the US, maybe you love the ice cream or pizza, doesn't mean you have the intent to immigrate. The second thing is that the consular officer is supposed to take a long-term view, and not just consular officers, including USCIS officers as well. And what do I mean by that? Maybe in the applicant's home country, there's something that's happening that is not optimal. That doesn't mean that that person suddenly has an intent to immigrate to the US. Let's take, for example, an earthquake, natural disaster, particular political turmoil that is arguably short-term. All of these situations may cause people to have a desire to leave the country temporarily, but that doesn't mean they have the intent to immigrate. Consular officers and USCIS should take that into account. Number 3, residence abroad. I know a lot of people have this concern. Maybe they have a Canadian citizenship, or maybe they have another country's citizenship, and they are applying for a US E-2 visa or some other visa, and you need to show you have residence abroad. Well, what if you don't have any residence in Canada where you have your citizenship? I know that sounds weird, but more people than you imagine actually are in this situation. Well, here's a case law that directly states it's okay that you don't have the residence in that particular country where you have the citizenship, as long as you have residence in another country, because the principle of the law is you must have residence abroad. Let me directly read it and share that with you. The residence in a foreign country need not be the alien's current or former residence. For example, a person living in Germany may meet the residence abroad requirement by showing a clear intention to establish residence in Canada after a temporary visit. So that is actually in the FAM. The residence abroad required need not be in the country where they are applying. Number 4, dual intent. So everybody knows dual intent covers H visas and L visas. Well, right here in Kurzban, it clearly states dual intent is recognized for H-1B, L, O, and P. There's so much confusion regarding this. If you're Googling this, if you're doing ChatGPT, you're going to get all sorts of confusing answers. But right here, I'm sharing the source. We're going to share the case law so you can read it for yourself. Dual intent for O1s and O3s. Visa applicants need only express the intent to depart. So there's these things that you can take into consideration when you are applying for these visas. Number 5, B1, B2 tourist visas in lieu of other visa categories. For example, B1, B2 in lieu of E2. These are all permissible. What that means is, even though you have the intent to invest in the US to do a E2 case, or you have already invested and you're in the process of doing EB5, or maybe your EB5 is already approved, but because of priority date, you are stuck abroad, it's okay to still apply for a non-immigrant visa without the intent to immigrate, and you are applying this tourist visa. So you come into the US to check out your investment. We've seen this very often, especially for people who've already applied E2, but the consular officer denies them because they don't think the case is good enough, the business is strong enough. So there you can apply for a B1, B2, and then say, thank you for adjudicating my case, but I still need to go to the US to take care of my investment. And then once it's stronger, then I'll apply for E2 again. Number 6, this is something that Kurzban warns against, and this is something that we've never used before, so we're giving it as a cautionary tale. But I didn't even know you can buy a bond. So what that means is you apply for a visa, and to guarantee that I will not overstay, I will not be an unlawful in the United States, I will not illegally work, I buy a bond. And so that if I do stay, well, then the government makes a whole bunch of money, right? In courts, people do that all the time, right? I will not depart the country. I have no flight risk, so I buy a bond so I don't have to stay in prison, right? Same thing for immigrants. I will buy a bond so that if I overstay my B1, B2 visa, if I overstay my E2 visa, well, the government makes all this money. I have already put down good money to buy this bond. Number 7, how do you enter the US? Some people don't have passports, or their passport expired, or their visa expired, but they need to come into the US, or the embassy is closed, the consulate is closed. All of these things can happen. Now, the power of the customs officer, the CBP officer at the border, at the airports, they have tremendous authority. And so we have seen cases where your passport is expired. You don't even have a passport. You don't have a visa, but the officer can waive that travel document requirement and still let you into the United States with an I-193 waiver. If you're able to get this waiver, then you can still come in. And we've just seen all sorts of examples where CBP officers were kind enough to help different people in different circumstances. Number 8, you can have multiple visas, but you can only have one status at a time, meaning you can have a tourist visa, you can have an L1 visa, you can have an F1 visa, and each visa carries with it different privileges and responsibilities. You can have all of these different visas, allowing you to come into the US with different varying statuses. But at the port of entry, you can only choose one, and they can only admit you on one particular visa. For example, if you come in as an L2 visa, a dependent of an L1 visa, sure, you can study, but if their L2 is expired, you need to change to an F1 to continue your study, or vice versa. And for many people who have multiple visas in their passport, you need to be extremely careful about this, because we did a case recently where somebody came in and they had an O visa, but the CBP officer admitted them as a B1, B2 visa, and then suddenly they've been unlawfully here in the US, they've been unlawfully working in the US, so they couldn't adjust. So we had to go back and change it after the fact and have CBP correct this. So it's extremely complicated if you have multiple visas. You need to double check with the online I-94 system to see exactly how you were admitted. Number 9, what nationality did you enter the US matters tremendously, especially when you are trying to apply for adjustment of status or change of status later on. For example, if you entered the US as a China citizen, well, as a China citizen, you cannot change status to an E2 because China is not yet a treaty country with the US. But if you have dual nationality and you have a Canadian citizenship, well, then you needed to enter the US as a Canadian in order to change your status to an E2. So if you entered as a non-treaty country, you need to leave the country and come back in, or you need to leave the country and go back to the consulate and apply for the E2 visa and come in. Number 10, I'm just going to read it to you. Can a spouse or child abroad apply for a visa to the US when the principal does not have that visa, or where the visa has expired? So Kurzban says, where a principal is in valid non-immigrant status in the US, a spouse or child may apply for and be granted a visa at a consulate, even if the principal never applied for that category or visa, or even if the principal had obtained the visa, but the visa has since expired. For example, if the principal changed status from F1 to O1, but never obtained the O1 at the consulate, a spouse or child of the principal may still obtain O3 at the consulate. So that is directly in the FAM. Now, what's really, really interesting about that is the CBP officers might find that to be an issue. And so you want to, even though they go to the consulate and let's say they're lucky enough to get that visa, when they fly to the US, I have seen CBP officers challenge them. You are entering as an L2, but the L1 never officially entered. We never inspected the L1, and somebody had to get returned back to their home country. And so we had to do a thorough explanation about this. So this law is particularly important with the consulate, but you cannot forget the CBP officers. You need to also educate them on it. All right, those are the 10 things we want to share in this first episode. I hope you found it interesting. If you have any questions or comments, feel free to reach out, let us know. And we're going to continue to do these. Hopefully you find it informative. Thank you. Take care. Bye-bye. Thank you for listening to today's episode. I know immigration law can be complex and oftentimes is frustrating. If there's any part that I didn't explain clearly enough, please reach out and let us know. But most importantly, if there's anything I got wrong or needs to be supplemented, which I'm sure there are, please let me know so I can let everybody else know. Thank you. I would greatly appreciate that. And that's it. To a better tomorrow. Cheers.